Welcome to the 9th module of the ICWA Education Series presented by the Nebraska Court Improvement Project in collaboration with the Nebraska Indian Child Welfare Coalition. In today's module, we will learn about the qualified expert witness provisions of the ICWA, including who can serve as a QEW, how a QEW is identified, and when a QEW is required. Qualified expert witnesses help the court to assess safety and well-being within the context of tribal family traditions that may not be those of the dominant culture. Under the ICWA and the NICWA, a court cannot make a foster care placement of or terminate parental rights to an Indian child unless the court finds that continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. To make such a finding, the court must consider a QEW testimony regarding whether continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child, as well as the prevailing social and cultural standards of the Indian child's tribe. Nebraska Revised Statute 43-1503, sub 15, defines a qualified expert witness as one of the following persons, in descending priority order, although a court may assess the credibility of individual witnesses. The first is a member of an Indian child's tribe or tribes who is recognized by the tribal community as knowledgeable in tribal customs as they pertain to family or child rearing practices. The second is a member of another tribe who is recognized to be a qualified expert witness by the Indian child's tribe or tribes based on his or her knowledge of the delivery of the child and family services to Indians and the Indian child's tribe or tribes. The third is a lay expert witness that possesses substantial experience in the delivery of child and family services to Indians and extensive knowledge of prevailing social and cultural standards and child rearing practices within the Indian child's tribe or tribes. The fourth is a professional person having substantial education and experience in the area of his or her specialty, who can demonstrate knowledge of the prevailing social and cultural standards and child rearing practices of the Indian child's tribe or tribes. Or the fifth and final is any professional person having substantial education in the area of his or her specialty.
So it's not always easy to find a qualified expert witness. There's an order of qualified expert witnesses, the first being someone from the Indian child's own tribe, down to the last, which I call just a very smart person in their field. I know working with tribes, the different tribes, they would prefer that we use either someone within their own tribe or someone that they recognize. But sometimes it's not always easy to find those types of individuals. Either you don't want to testify against someone within your own tribe, or there's just not a list. There's not a QEW list of people to use. And so usually in the prosecutor's office, we would use the very last listed person, the very smart person in their field. And usually it would be one, maybe two people to choose from. It's not a very large list. There's case law out there that a case manager with regular and ordinary training does not qualify as a qualified expert witness. But you need to make sure you have a roster of willing people to serve in that capacity, because your time frame is not very long. These hearings happen 10 days after the tribe receives notice. So you probably have about 15 days to work with, 20 days, and you need to be able to find someone pretty quick.
As you just heard from Judge Amy Schickman, in most cases the DHHS caseworker assigned to a case is not sufficiently qualified to testify as a QEW under the requirements of the ICWA. Let's listen to Pat Caraher, who was involved in the 2009 Nebraska Court of Appeals case in re-interest of Shayla H., which Judge Schickman made reference to.
About 2008 or 2009, and there were two issues in that appeal. One involved a qualified expert witness, because back then, sometimes the county attorney would just have the caseworker testify as a qualified expert witness, and that's what they did in my case. And the caseworker was a good caseworker, an experienced caseworker, and she testified that she had had Native families on her caseload, and she'd been to hearings that involved the Indian Child Welfare Act. But when the county attorney asked her for her opinion, I objected on foundation, saying there wasn't enough foundation for her to give that expert opinion. But the judge allowed that opinion. So I appealed that, and the Court of Appeals agreed that she should not have been allowed to testify as a qualified expert witness. They said, we're not saying that a caseworker could never be a qualified expert witness, but most of the time you need more experience in the delivery of services than what a typical caseworker would have.
It is important to remember that a QEW is not a legal expert and does not need to be an expert in the Indian Child Welfare Act.
I think it's important to know that QEWs, are not necessarily legal experts, and that, the descending priority order would be, somebody from the child's tribe first. And those people necessarily may not have child welfare experience, they may not be ICWA experts, and they may not be legal experts. And so not expecting them to answer questions about ICWA or, to consult in that way. I guess that's something that has been done to me. I'm being asked questions about ICWA and how things apply and how they don't apply and how to interpret things, and that, it's been questions that I can't answer.
I think that's a really good point, Misty, that qualified expert witness, when we're meeting that very first top priority order of a member of a child's tribe, that person is solely expected to be knowledgeable about the child rearing practices, the family organization and structure of their tribe and their tribe's culture and customs and way of life. And that's what they're really there for. And that's why in Nebraska, we do have that descending priority order still, because we recognize that the federal government's intent was to prevent that cultural bias from coming into play.
Now that we know who can serve as a QEW, let's find out how a QEW is identified. The court or any party may request the assistance of the Indian Child's Tribe or the BIA office serving the Indian Child's Tribe in locating persons qualified to serve as expert witnesses.
I think what I would add about QEW testimony and finding a QEW is that talking with the tribe's ICWA specialist or ICWA attorney, ICWA worker, however the tribe refers to that position, is important at the very outset of your case to identify who the tribe has identified as a QEW for their kids. If the tribe's ICWA specialist at times may be that person.
A QEW is required at two junctions in a case, where the court orders the foster care placement of an Indian child and where the court orders the termination of parental rights. Under the NICWA, the party attempting a foster care placement must prove by clear and convincing evidence, including testimony of a QEW, that a parent's or Indian custodian's continued custody of the Indian child is likely to result in serious emotional or physical damage. The party attempting a termination of parental rights must prove beyond a reasonable doubt, including testimony of a QEW, that a parent's or Indian custodian's continued custody of the Indian child will result in serious emotional or physical damage. It is important to keep in mind that the role of the QEW is to testify to the likelihood of emotional or physical damage to the child and to speak to the prevailing social and cultural standards of the Indian child's tribe. The QEW is not a legal expert.
The other thing that a qualified expert witness is there for, besides to prevent that cultural bias from coming into, is, like I mentioned earlier, to testify to whether serious emotional or physical damage is likely to occur. if the child remains with the parent or is returned to the parent at the time of their testimony. That is the be-all end-all question that QEW must answer under the law, both the state statute and the federal statute. I know that a lot of parties also tend to ask questions about whether active efforts have been provided, whether placement preferences are being met, those types of things. That is okay to ask those questions, and if that person knows and feels comfortable answering that, great. But they don't have to testify to that.
Beyond providing in-court testimony, a QEW can be a helpful resource when creating a cultural plan. As a reminder, you can learn more about cultural plans by rewatching Module 8.